fifth most asked question, which is something I can address. Do I need to incorporate? Now, I like to start to answer that question with a story. And so I am going to tell you the story of my favorite person in the world. He is Archibald Reginald Wilkins III, or he likes to go by Bob. Now, Bob has a brilliant business plan. See, Bob is going to do door-to-door sales, and he's going to sell only two products. He's going to sell lemon-lime flavored soda, and he's going to sell lemon-lime flavored laxative. Now, Bob's big competitive advantage is that he's going to save costs by using the same type of can and the same label for both the laxative and the soda. But because he's not a fool, he's going to put a sticker on the laxative can that says, it's a laxative. So this is going to be a brilliant business model, and he's going to move forward with this. Now, Bob goes off and he incorporates Bob's Sales, Inc. because he incorporates for a number of reasons. One of them is that he wants all the profits from Bob's Sales, soda and laxative, to be taxed separately. So he creates a company. He also was aware that he might be sued. And his idea, though, is he's going to be sued by all those pro-constipation activists that are going to be furious about his changing the constipation marketplace to the worse in their mind. And so he goes down to a registry's office. He pays the $400. He gets 5 pieces of paper from the registry agent. He says, today, Bob Sales, Inc. exists. And he moves forward on his door-to-door laxative and soda sales, comforted and comfortable in the knowledge that he is going to be safe behind his incorporation. But then tragedy strikes. There is a celebratory soda on a hot air balloon on a wedding proposal that goes terribly awry, where what was thought to be a soda was actually a laxative. And he now asks the question, did incorporating help me prevent the liability from a very disappointed newly engaged couple? And so before I can answer that question, and I wish, by the way, I can't claim that this actually was a true case that walked through my door, but I can claim that this was actually, I've had sillier issues walk through my door as a lawyer over the last 25 years. But before I answer that question, let's start by what is a company? So a company is actually a legal entity. It is considered a legal person in law in Canada. As a legal person, it can do things that individuals are human beings, people that are born, people that have social insurance numbers. But legal persons can do things that individuals can. They can both hold property, they can both enter into contracts, they can both conduct business, and they can both pay taxes. But there's some things that a business and a corporation cannot do. It can't die. It can't give gifts. It can't throw a baseball. Only individuals, unfortunately, are able to die, give gifts, throw baseballs, run, hold a pebble in their hand. These are things individuals can do that corporations cannot do, because a corporation is a legal construct that its entire physical existence is a bundle of paper that sits in what's called a minute book. So because of that, corporations have no arms, they have no mind, they have no pockets. They need individuals to do things for them. And the number one individual that the corporation looks to do things for them is the directors. The directors are the brains of a corporation. Whenever you create a corporation, you do not have to have shareholders, but you must, by law, have a director. A director must, by law, be an individual. It can't be a corporation itself. It has to be this human being, because it's the person that is going to be guiding and providing the big picture day-to-day operations of the company. It is the director that decides, I am going to go into the business of selling soda and laxative door to door. The next step, though, is, well, okay, that's the brains. What are the arms, the hands, the legs of a corporation? Well, those are the corporation's agents. Now, the agents of a corporation can fall into 3 categories. They can be the officers of the corporation, the chief executive officer, by example. They do the day-to-day things. They can be contractors. You can hire a sales rep to go off and find houses that might be interested in buying your soda and laxative. They can be lawyers, accountants. These people have their powers limited by a contract. You enter into an agreement between the corporation and a sales rep to say, I want you to go and hand out pamphlets for my company. Finally, the last of the agents can be an employee. And they also have their powers by contract. But an employee is a little bit different than a contractor in that it's got an ongoing employment relationship with the company. And more importantly, it means that the company has to withhold taxes when they're doing business with them. That's the more pragmatic difference between a contractor and an employee. So these are the three, if you will, hands, ears, and feet of a corporation are its agents. The director is the brains. Now, all power starts at the top with the directors and flows down to everybody else. I like to think of it as a waterfall. The directors can maintain all power to deal with the company to themselves, or they can allow a little bit of that water to trickle down and fall upon the officers. They can create a chief executive officer that says, we're going to devolve all operational power to you. They may even delegate some to their agents or to employees. But the key thing here to understand is that it all starts with directors, and then the directors get to decide where it ends with. Now, where do directors come from? Well, I know my daughter approaches me when she was young. I go, Daddy, where do directors come from? And the answer is, well, when two shareholders really love each other, they vote and elect a director. And that's where directors come from, the shareholders of a company. So shareholders only have the ability to do three things. And some of them, you can actually separate the power to do these three things between different share classes. But in the end, there's got to be shareholders that can do these three things. One, they get to vote at a shareholders meeting, which usually happens annually, and it's at that shareholders meeting they elect the director for the following year or directors for the following year. Second thing a shareholder gets to do is participate in the profits of the company. When the company declares a dividend of its profits out to the shareholders, then that's where the shareholders can get the cash. The third thing is they can receive the assets of the company upon its winding up. That's the only thing shareholders get to do. Being a shareholder is not a great big deal if there is no profits in a company, because then all you get to do is to show up and vote at a meeting and receive the assets on winding up of a company. And here's the bad news. If a company is winding up, odds are it doesn't have much assets. It's kind of a chicken and the egg thing that happens with companies. The role of a shareholder is entirely passive. And because it's entirely passive, by law, shareholders have no responsibility or exceedingly limited responsibility for the asset or for the liabilities of a company. They also have limited responsibility for the actions of the company. This is where people get confused. They say, I created a company and I am a shareholder, therefore I cannot be held liable for any of the actions of the company, which in general is true. There's a few specific exceptions, though, and they're mostly incorporated by statute, and they mostly relate to environmental protection laws. Thankfully, there was a lot of gas wells and oil-bearing properties that were left fallow, if you will, and the government had to step in and say, if you are going to leave a bunch of oil on the ground, you can't stand behind the fact that you are simply a shareholder and get away with it. But for most cases, shareholders have no liabilities for the company and they have no liabilities for the actions of the company. So because of that, if we go back to our story, we're all going to say, well, Bob is absolutely saved then. Here's the good news. Bob incorporated, and as a shareholder, he's saved. And it's not necessarily the case because he was protected as a shareholder, but Bob was also the sole director, the sole officer, and the sole agent of Bob's soda and laxative sales. And so while Bob is not liable as a shareholder, he is liable as a director of a company that was engaging in risky and some might argue stupid behavior of selling a laxative and a soda in the same can with just a sticker between the two. He also was liable as the sole officer of the company for carelessly supervising the application of the "It's a Laxative" sticker at the warehouse, or perhaps not using a adhesive that wouldn't dissolve in the humidity or with condensation. And finally, he is probably liable as an agent in negligently selecting and passing over a can as soda, which was actually a laxative, to our poor newly engaged couple who discovered it was a laxative when they were in the middle of a hot air balloon ride. So we're not so sure that incorporating did Bob any favors from protecting himself from the risks associated with his business. But that's not to say that there aren't advantages to incorporating. It's just that the advantages for a sole shareholder, director, and officer of a company, a one-man operation, the advantages don't lie in protecting yourself from liabilities. They lie in other areas. So if the company has many shareholders, and those shareholders are not the agents of the company, they're purely passive, then yes, the company will protect them from the liabilities of the company. But there's also other advantages of the corporation. It's an independent person, which means it can file and taxes independently of the individual. It means that the profits of the company are not taxed by the shareholders, they're taxed within the company. And in Canada, there's some very good small business deductions and very good tax rates for small businesses that we experience. If a individual was to earn $500,000 from a business it was operating as an individual, they would pay tax somewhere between 37 to 42% of their profits. They would pay tax as an individual in Alberta. A small business might actually be in the 10 to 20% range. So there is some significant benefits on the tax side of incorporating. A company can hold property. So there's a benefit there that you can have the assets of the company not held by an individual, but instead by the company. And maybe more importantly, is that a company can have many shareholders. It can be very complex if 5 individuals want to go off and do a business together without the use of the company, because in that case, you're dealing with agreements of how you're going to handle assets, how you're going to handle expenses, revenues, profits, whose bank account does it sit in. You can incorporate, have 5 different shareholders, and it makes it much easier for people to work together towards a common goal. So there are advantages for a corporation. It's a great way to work together with multiple people. It's a great way of making sure that the profits are taxed separately from the individuals. And hey, let's all face it, it is so easy to create one. You can even create them online now, I've discovered. Where you can log online and you can get it within an hour. And so it's really a problem, though, from the lawyer's perspective, because it's really easy to do this wrong. There's many people who believe that to start a successful company, all you need to do is 3 steps. Go to the registry office, start issuing shares, and it's in quotation marks too, because some people just believe you have now issued shares and that you've done the job. And step 3 is profit. So piece of cake. And I'm here to say no. There's a lot of landmines that people run into that you should really be aware of before you start going off and incorporating a company and operating in a way you think that you can, but maybe the law doesn't support. So there's 5 really big problems that people should avoid, but they just don't avoid often enough. And they break into 5 kind of categories here. The legal requirements around a company, there are certain steps that you have to be aware of that you do need to do that maybe the people online or the registry office isn't going to do for you. There's securities rules and securities regulations. And many people think that only applies to big public companies. And the answer is no. It applies in particular more to small private companies. And you can get yourself into a lot of trouble with the Securities Commission by doing things wrong. There's some tax issues that people can trip into. There's issues with dealing with your shareholders, and then making sure finally that your company owns what you think it owns. And I'm going to step through those a little more in detail as we on the following slides. So the first thing you have to understand is that the pieces of paper, 4 to 7 pages that the registry office hands to you, is not the end of incorporation. It is just the beginning. The law is really quite particular and clear that you need to do things to have a company validly exist. You need to have minutes or resolutions of an organizational meeting of first the directors and then the shareholders. They need to get together and you need to write these things down, and you need to actually put them in a book called a minute book that is going to be kept and held somewhere in Alberta. You can't just simply jot it down, and an email between people isn't good enough. The law says you need to have these meetings and you need to document it and keep it into a central location. You need to file you have to have annual shareholder and director meetings. You can't just create a company and then 5 years later decide, where were we at? No, you're supposed to be doing this every year, and you need to file an annual return with the corporate registry's office here in Alberta. It is arguably simply a taxation regime. It's the government's way of making sure it gets $50 or $65 a year from every company in Alberta. But it's also the law. And if you don't file it, then you could actually have your company completely dissolved and disappear from underneath you without you paying any attention to it. The government will send you notices to say you didn't file your annual return. If you don't file it, we will dissolve your company. But and we'll come to this in the addresses, the government may be sending it to an address that you're not at anymore, and that might be a real problem. You have to issue share certificates. You can't just simply say to somebody, I'm going to give you 20% of the company, shake hands and walk away. Your minute book is supposed to have the share certificate, which has no special form. You don't have to use one with gold embossed labels, but you do have to have a piece of paper that says this person owns 20 shares of a company that has 100 shares issued. And if you don't have that, then you're going to run into some real issues later on down the line. We'll talk about the process of issuing shares and how that can be a problem in a little bit. You have to maintain a register of directors and shareholders, and more importantly, a register of any matters the directors have voted on in which there was a conflict of interest or any self-dealing. This is by law in the Business Corporations Act an absolute mandatory thing that needs to be in your minute book. It is really easy when you are a sole shareholder, sole director, sole officer of a company to do a lot of self-dealing. You think it's your company, what's the big deal? And to a large extent, that's absolutely true until your business is successful. 5 years from now, you bring in other shareholders, otherwise known as investors, who've bought into your company, and that you've got this hidden liability that's been floating around in the back of the minute book that is discovered invariably at always the worst time for it to be discovered. And it usually happens when somebody says, I want to buy into your business. I would like to buy 10% of your company. And somebody goes, I would love to sell you 10% of my company for the amount that you're offering. And they go, excellent. We just need to do a little bit of diligence. So we're going to look at your business operations, which we're sure are going to be great because we've looked at your business. And we just need to see your minute book. And there are a number of clients of mine who I have met simply because they go, a minute what now? And they go, a minute book. Your minute book. We're going to buy 10% of your company, so we need to make sure that your company is validly organized. And they go, oh, yes, of course, the minute book. Yes. I'm going to just make a call on something else. And you suddenly discover that you're spending an inordinate amount of time and money to create a document and a book that should have been created 5 years before. But frankly, the registry office misled you when they handed over your documents on incorporation. They didn't give you everything you needed. They gave you only the bare minimum you needed, and you needed to take these other steps. I'll say, do you need to go to a lawyer to do this? A creation of a minute book? Maybe not. Maybe you don't need to go to a lawyer for this. When it comes to issuing shares, I would absolutely encourage you to find legal counsel. But on the minute book side, if you would have stood in the registry office and turned to your left at the little carousel that they have there where it has the legal will kit, they will also have a kit on minute books that are there for $35 to $55 that has all the forms that you need to create your minute book. Buy those forms. And more importantly, don't just buy the forms, fill them in, read them, fill them in properly, and then every year hold your meetings and they will have a form of what a resolution looks like for your annual resolutions. Because you don't always have to have meetings. You can instead, if everybody agrees, just have a written resolution to the same. You don't need to go to a lawyer, but you do need to have these documents. The final thing here is this registered address and records address. And this is a real sticking point for a lot of people. So a registered address is a place in Alberta that the corporation can be served documents. And individuals are served legal documents in a different way than corporations are. As an individual, I might very well have to have the document placed into your hands or placed before you. Process server, as we might have seen on television, is a little exaggerated, but it's not far off. If I want to serve an individual, then I probably have to get that legal document into their hands. But a corporation is different. I just have to leave it at its registered address. And more importantly, it's deemed delivered whenever I drop that off at the registered address. And this can be a real problem for people if they set their home as their registered address. Because people and individuals go on vacation. Corporations never do, but individuals do. So you could very well be served very important legal documents that have a time constraint on them in some way. If you were served a statement of claim, I believe you've got 14 days to respond in Alberta. Well, if they are served right before you go on vacation, if they are served to your office for your business office address the day before Christmas, and you take a 2-week Christmas break, well, there is no I wasn't there. They were deemed served on the day they were dropped off. So using your home address or using an office address that isn't regularly staffed can be a real problem for your for using that as your registered address. But maybe more importantly is the records address is where your information on all your corporation is kept. And the law says that certain individuals, even people off the street, can go to your records address and demand to see certain information. And by law, you have to provide it from your minute book. And if you don't, then you can actually there's fines associated with it. And they can be quite significant. So having your home as a registered address has its risks associated with service, but having your home as your records address means that you may very well have an individual showing up at your door during normal business hours, knocking on it and demanding to see a shareholder list. And you don't have a shareholder list, or more importantly, maybe you don't want people knocking on your home address, asking for that. So it's something to just keep in the back of your mind when you're saying, well, do I want to incorporate on my own? Do I want to incorporate through my accountant? A lot of accounting firms do this, and there's a lot of paralegal firms. You don't always have to go to a lawyer to incorporate, but before you decide that you're going to use your home, be aware at least of what you might be opening yourself into. People are going to know your home address. They're going to know where you live. And in the days of white pages and yellow pages for our youngins, these were large books that contained the address and phone number of every individual with a phone. That wasn't a big deal. Everybody knew where I lived because it was in the telephone book. Not so much now. And so people should be aware if you're going to go and incorporate a company, then lo and behold, people are going to know where your records address is. And it's going to be pretty apparent if it's a unit number of a high-rise tower, that's probably where your residence is. So just keep that one in mind. A real sticking point is selling shares. So people create a company, they want to go and find investors, or they want to give some friends and family or people that they know a piece of the company. They want to hire outside agents to do things, web designers, for example. And they say, look, I don't have a lot of money, so I won't pay you in cash. I'm going to give you 10% of the company instead. Well, there's some important considerations on whether you can sell those shares. The legalese around this is no security may be traded absent reliance upon an exemption to the prospectus requirements and by otherwise complying with all applicable laws and regulations. That's the legalese. The plain English is you start with the position that you cannot ever sell a share in your company unless a lawyer tells you can. Remember that. You can't sell a share in your company unless a lawyer tells you can. Why? Well, because the Securities Act starts with just the position that nobody can sell a share. You cannot sell a share, period, unless you do certain things. And the big thing is the prospectus exemption. That is otherwise known as going public. All those public companies that people trade, they are relying upon prospectus exemptions and regular filings and public notifications to allow people to buy and sell their shares. Now, there's plenty of other ways that your company can legally issue and sell shares to investors, but they're probably not as many as people want or would like to think that they have. You can sell shares to your friends and family as long as they are truly your friends and family. It's considered close business associates and personal friends, as the phrasing that's oftentimes used. I had somebody come into my office that said we had 372 between myself and my director. The two directors had 372 close personal friends and business associates. 372. Now, the Securities Commission took the position that they don't know how many friends is too many close personal business associates and personal friends, but 372 is probably more than that. And so keep in mind that you might not be able to easily sell shares to people that you want to. But there's plenty of exceptions and plenty of ways to sell the shares to the people that you usually want to be able to give shares to: friends, family, wealthy individuals, investors. Look, we can get you there as lawyers, but just be aware that you can't just give shares out to people, because if you do, you probably are going to run into issues. No, if you do, there's a potential securities liability out there. I can assure you that when your company is profitable and people are making money, nobody complains about how you sold them shares. It is only when people have lost their money, it is only when people, the company didn't do as well as they'd hoped, that people start to look around and go, hey, maybe you shouldn't have even sold me those shares in the first place. I think I want my money back. And so it's never in success that people ask the question, should you have sold the shares? It's only in failure, which just adds to the problem of your business not doing as well as you'd hoped, to then be thrown into the difficulties associated with, should I have sold the shares in the way that I did, or should I have done it a different way? There's also reporting obligations to the security commissions for many of the ways that you can sell shares, and consequences. I mean, civil lawsuits, fines. There is the expectation or the ability for the Securities Commission to put people into jail for these things. It is rare. Look, somebody accidentally selling shares to their professor and taking money for him as an investment is not going to put you in jail. I'm not pretending that it will, but it could lead to fines, and it could lead to your professor suing you because you didn't do it right. Or it just could lead to the fact that an investor 5 years from now comes in and hires a lawyer like me to go through your minute books and go, actually, the company's got some skeletons in its closet. There is no evidence that the 3 people that were given shares 5 years ago were falling within an exemption under the Securities Act, and so we need to fix this, or we need to walk away. Usually it's a fixable process, but it means it's going to cost money, it's going to cost time, and it's going to interrupt the thing that you wanted to do, which was get investment or enter into a business relationship with another company, or whatever the case might be. Taxes are a real issue. A lot of people create companies, start their business, open a bank account, get revenues in, pay money out, and they forget that they actually have to file a separate tax return every year for that corporation. So this can be a good and a bad thing. So the bad thing is, if you forget to file it, then, or when you do have to file it, you have to pay somebody else to file this for you, or you're taking the time to fill it in yourself. But it also has some negatives. So when a company is profitable, it is wonderful to have those profits taxed inside the company as opposed to in the hands of the individual. But when a company is not profitable, those losses are locked up in the company and you can't use them. So there is a standard life cycle for a business where people will start a business as an individual. It's called a sole proprietorship. They will start the business as an individual and come to the point where they are now making money, and they will use that money to then incorporate and then have the business now run by the corporation rather than themselves. One of the reasons that is done is because when you are losing money as a business, as a sole proprietorship, you get to claim that off your other income. If you were to incorporate and start off the bat, then those losses get trapped in that company, and that can be a little bit painful because you are the one that's financing the company by writing a check to Bob's Sales Inc. to be able to keep it running. But you can't write that $5,000 check that you wrote to Bob Sales Inc. off from your own income tax. That's called an investment or a loan. It's not considered a write-off. So the taxes can be good and can be bad, but more importantly, they exist and you got to file them. So you got to keep that in mind. Second to last issue here is shareholders. Boy, if you thought it was uncomfortable listening to your uncle's politics at Thanksgiving dinner, wait until you take some money from him to start your business. And he starts screaming over the turkey as he's spitting dressing all over the gravy, "I pay your salary. What's going on? Where's my money?" It can feel great to get an investor and have Uncle Bob as part of the team when things are going good, but boy, that can turn quick. So keep in mind that getting additional shareholders means that you have other voices. They might have minimal voices according to the law, but they will see themselves as having maximal voices because they're shareholders. It's a great idea to get everything on paper. Make sure that you understand fully exactly what they're getting, what they're not getting, that get on paper that they understand that this is risky and it's a high risk. It's not just a good idea, it's the law. There are a number of exemptions for issuing shares to people that require you to have them fill in what's called a risk acknowledgement form, which is simply them saying over and over, I acknowledge this is a risk. I acknowledge I can lose my money. I acknowledge I can lose all my money. I know this is a risk, but this is the law. You need to be doing these things. You might also be looking at a shareholders agreement. Shareholders agreements are kind of like prenuptial agreements for companies. A good shareholders agreement addresses how the shareholders are going to work together. A great shareholders agreement addresses how shareholders are going to not work together. What happens when there's a disagreement where people don't want to be in the same business together? And it is so important to get that breakup language in writing. I've drafted hundreds of shareholders agreements through my career. I have 3 to 5 kind of template shareholders agreements that I start with all my clients. Create a company, you're going to start business with somebody else. If you're going to have more than one shareholder in that company, go to a lawyer, get a shareholders agreement, read through it, understand what it says, and consider strongly using one. Because shareholder disagreements can be so crippling to a company as things move on. And it can all be just simply addressed by what's called a shotgun clause. And a shotgun clause, although now I think it's a rather violent phrase for what is a beautiful clause. And the beautiful clause simply says, any shareholder can say to the other one, I'm done. I am going to offer to buy your shares. And you have 2 choices. You either sell me your shares within 30 days, or you buy my shares at the same price in 30 days. There is no other choice. It's kind of a clause that says in day 31, either you're gone or I'm gone, but there's no world where we're still here together. Why do I say it's beautiful? Well, because it's an uncomfortable 30 days, but it means that mommy and daddy fighting, or daddy and daddy fighting, or mommy and daddy and uncle fighting for the last 6 months is going to end in 31 days. So shareholders agreements do this. Consider strongly getting a shareholders agreement before you go into business and start issuing shares to other people. The final thing to keep in mind is company property. So people will create a company and they will say, excellent. And in their mind, or perhaps they will step into a darkened closet, they will say out loud the words, my business is now owned by my company, ipso facto relaxo. And then they will walk out comfortable in the belief that their company now owns everything. Well, if a company is simply a bundle of piece of paper sitting in a minute book at a registered office, I assure you transfer and ownership of property needs a couple of pieces of paper. And so you need to be documenting what your business owns and what it doesn't own. Get it down on paper. Why? It's not going to be relevant it's never relevant until it's relevant. And it becomes relevant when that investor comes in and says, we want to invest in your business. And they discover that your company doesn't own anything. It has a bank account. All the profits and revenues and expenses have been coming out of that bank account. But the web domain is owned by the individual. The brand is owned by the individual. The ideas, your trade secrets, your intellectual property, your assets, well, they're all sitting in the individual. They're not sitting in the company. And that's the worst time to discover that when you're looking for investment. So just document it as you go along. Keep in mind credit applications. A lot of people like to start companies because they can say, well, you know what? I'm going to have this lease not held by myself, but my lease for my commercial or my office is going to be held by the company instead. But what they miss is at the bottom of the application or at the bottom of the lease, it says, I, as an individual, guarantee that the company will live up to all its obligations. Well, what was the sense of creating a company if you're just going to personally guarantee all of the debts for the company? Credit applications. I had a large construction client had about 800 employees, and it wanted to get bottled water into its offices. And so at the bottom of the bottled water credit application, it said signed on behalf of the company by blank. And then in small print underneath, it said the individual signing this on behalf of the company takes personal responsibility that the company will pay. Well, some poor person in accounting who has only the ability to sign contracts for less than $75 per month is now going to be held individually responsible if the company doesn't pay its water bill at the end of the month. Well, that's what the credit application was doing. So if you're going to go through the effort of creating a company, pay some attention to the credit applications you're entering. Pay some attention to your leases, to your contracts. Make sure if you wanted to protect yourself as an individual from the liabilities of the company, that your actual agreements that you're signing on the company say that. That can be very important. Finally, inventory. Protect your assets from seizure. If you go into business with somebody and he is going through rough financial times, really relevant right now, he might very well go bankrupt. You want to make sure that he doesn't have any of the company's property in his personal possession. Or if he does, that you've documented that it's not his, it's the company's. Because when the receivers come in, when he doesn't pay his rent and the landlord comes in and seizes everything that's inside the leased or rented premises, it's called landlord distraint. When that happens, it's really important to have some good documentation to say you might have been able to seize it, but it wasn't his, it was the company's. So go through and make sure that the company owns what the company owns. And part of that is that the company is owning its liabilities and that you're not accidentally or intentionally on the part of the creditor agreeing to sign in on that. So finally here, what are the lessons to take away? The key thing is that a company one size does not fit all. There are some businesses that properly maybe shouldn't be sitting in a company. There are some businesses that properly should be sitting in a company. It is common that almost all businesses should eventually end in a company. And that's just strictly the moment you start hiring employees is usually the sign. The moment you have people other than yourself doing things on behalf of the company, or on behalf of the business, I should say. The moment that you have people doing things on behalf of the business that are not you is when you should probably consider, should I have a company? That's on the liability side. On the other benefit side, well, that you might very well want to have a company because you want the great vehicle write-offs that you've heard about that you can have if you use your personal car for company business, or you might do it just to be able to have that separate taxation of profits, etc. There's lots of good reasons. It's real hard to give a one-size-fits-all answer to people. Keep in mind that just going to the registry is not enough. Going online to legaldocs.com and incorporating your company may be enough initially if they do all the documents for you. And I've seen them and they're actually quite good, but you've got annual obligations. You've got, you need to have a registered office. You need to have a records office. Do you want that to be your personal residence? It can provide asset protection if you're set up correctly. Make sure you do the paperwork to get everything that you want to have the company own into the company. And finally, and most importantly, use completely different labels if you're going to sell soda and laxative in the same cans. Like it's just a bad idea. Maybe don't even sell them together at the same time. That's where I would come from. Okay, that is the end of my long and laboring presentation. I love answering questions because it makes me feel like a know-it-all. So I would be happy to answer or to open the floor for any questions that might exist.
Does anybody have any questions? It'd be great if you turned your camera on and unmuted. But if you're too shy, use the chat.
Except for Xenia LaRose, because there's the cutest puppy on that one. I don't want that one to change.
Okay.
I'm a dog guy. What can I say?
Can I go ahead?
Yes.
Yeah. Thanks, Craig, for the talk. I have a question. My question is, I don't know if it's kind of related to this, but the question would be, when you're starting a business, what informs whether you should do a sole proprietorship or you should go a liability company. So is it the size of the company? For example, when you're starting up and you are maybe yourself and your spouse that is doing the company, what determines if it should be sole, a partnership, or a limited liability? I don't know if you want to touch on that.
I can, and it's so fact dependent upon what the business is, and there's no easy answers one way or the other. I can give you some extremes. If you are going to open a bar, you're going to sell liquor to individuals. And if you are going to have employees that are going to be doing these activities with you, alongside with you, so you're not the only person selling the liquor, you're going to have 3 or 4 other people as bartenders and waitresses, etc. That's an example of where you want to be a company. You want to have an isolation between yourself as an individual and what other people are doing on behalf of your business. If, on the other hand, you are doing everything yourself, there is no one else, and you're in a situation where if there was ever a liability that arose for your business, it's because you did something wrong. You are doing tax preparation, for example. Right? There is very little chance that somebody is going to get a dangerous paper cut from your tax forms. Your liability is all going to be because you filled in a tax form wrong. Well, is there any benefit to you creating a company for that? Because if you are going to get sued for filling in a tax form wrong, they're going to name the company that they paid, and they're going to name the individual that filled in their tax form for them, which is you in that lawsuit. And you're going to have great difficulty as the sole director, shareholder, and officer of the company to completely escape liability if you did something negligent in the filling of the tax form. Could you avoid liability if it wasn't negligent, if it was just an accident? Because the law doesn't necessarily punish accidents, it punishes negligence. Well, yeah, there's a possibility that you could shelter yourself behind the company in that case. But these are just examples of the two sides. One, you do everything, but if you are going to be sued, it's probably because of your negligence or some willful action that you as an individual did under the guise of the company, versus having an operation that's going to have many different people all working on behalf of the business, in which case you probably want to have the company between yourself and what those other individuals do, all in the name of the business. In between there, it can be very complex. So there's no real quick and easy answer, I'm afraid. Although I'm full of opinions when people phone me and tell me what their business is, I can listen and I can say, look, here's what you should probably be doing. Here's what I would recommend that you be doing, both as a lawyer or putting on my businessman hat. I'm more than happy to provide that on a one-on-one basis. Thank you. My pleasure.
Any other questions?
Hey, Craig, what do you charge for a corporation?
Yeah. Who asked that?
That's too personal. I don't want to
Dale. No. So I can tell you the ranges and where I am. So I have seen the ranges on incorporation all the way from $600 or $400 if you go to a registry office, $450. And essentially that's just the government filing fee. That's the payment to the governments, all the way up into the multiple thousands by going to the big law firms. I charge a flat rate at my firm for $1,200. For $1,200, I act as the registered office. I create a minute book on a binder. It has all the share certificates, and it includes all the fees, including usually a name reservation, unless you want a numbered company. I am not the cheapest, and I pride myself on not being there. I'm not the most expensive. There's a lot of people who can't afford it, in which case I'll point them in the right direction to go to the other places if that's too much. But it's exactly where we chose to be here at my office. By the way, I'll come out and say it. $450 is too low. If you're paying $450 because you're just getting those documents, pay $450 and buy the legal minute book kit from the registry office. But whatever that's going to cost you on top of that. But people who at the $450, I can say that's way too low because you didn't get anything you need. $2,000 is probably way too high. I literally had somebody come into my office. The binder that the law firm charged, put their books and their minutes in, it was a very fancy binder. It cost more than my first car. They got charged $575 for the binder and the seal and the little cupboard that fits into the binder. It was $575. My first vehicle was $500. That's way too much. $450 is way too low. Find somewhere in between. Well, it means I answered every question in anticipation. I think this is a win for me, guys.
Let's give another, I'll ask. Rachel, do you have a question?
Yes, I do. Thank you, Craig. So I'll try and get this out. I'm not the best with words, but would you say that a business that chooses not to incorporate is hindered in, say, scale-up operations or in investing possibilities? At what point in time, other than having employees, should you really consider that? And do investors look at that as, you need to be incorporated to be legitimate in those scale-up activities?
Again, really dependent upon the business, but there's some statements that I can make. The first is, the moment you're looking for investors, it's really hard for investors to invest in a sole proprietorship. What does that look like? It looks like a loan. You can finance a sole proprietorship. I can give you a loan to go off and do business, and maybe I get some interest back. But how do we create a document that says, I'm going to give you $10,000 and you promise to give me 10% of any of the profits from your business? Well, yeah, you can create that contract, but it gets difficult. It gets messy. If you have a corporation, then not only do they have a promise that they get 10% of whatever the profits are of the corporation simply by virtue of their having shares in the company, but they then have this whole body of corporate law that they can fall back on to make sure that their investment is sound and secure. They have a voice on what is owned by their investment company, etc. But that's kind of a global on the investment side. I don't think that a business is necessarily hindered by not being incorporated, depending on what the business is. So if your business is life coaching and you are a sole practitioner, a single person providing life coaching, you have no assistant, you have nobody else on your team, then I would say creating a corporation might very well be hindering your business in that case. You're a sole person who is doing a services business that you yourself provide all the services for. The incorporation might actually be an expense and a difficulty that you don't need. On the other hand, the moment that you have other people underneath you, the moment that you have assistants, the moment that you have intake personnel in that lifestyle coaching, the moment you have other life coaches, is the moment that you might be signaling to yourself, this is where maybe I want to have a company. It makes it easier for addressing what the corporate interests are, where the liabilities are. If you do not, if you have a problem with one of your life coaches, you discover, unfortunately, after they've been giving 30 sessions, you discover your life coach's answer is just to end it all. You go, oh no, that's not right. Well, if they were paying you, Rachel, if the customer was paying you for receiving these poor and negligent services, they're probably going to have something to say against Rachel. You might very well want to have a company in between there to be able to potentially isolate yourself from that lawsuit of improper and negligent lifestyle coaching by somebody that wasn't Rachel. So that's where that general truism is. The moment you have other people performing your business with you or for you is probably the moment you want to be asking, do I need to incorporate? Good question.
Okay, awesome. Thanks for that.
Any other questions? Going once. Twice. All right. Well, thank you so much, Craig, and thank you everyone for joining us. I really can't thank you enough, Craig. You're awesome. And Craig is one of our very, very valued mentors.
And I want to thank you for sending me all these great people. It's nice to help. And so if I can encourage everybody on the call to be looking to your Mauji team, they will connect you with the people that you need to be connected with. I love spending time with people up to an hour, sometimes even longer, just hearing about what the business idea is, and I can point people in the right direction of where to go. It makes me feel like I'm giving back to the community, which I won't go into why I have a karmic imbalance to work off, but boy, do I need to work it off, guys. So reach out to your Mauji Center team, and I'm more than happy to be on the other side of that too.
Awesome. Everyone, just to note, reading week is coming up, yay. And then on February 24th, we have must-haves for marketing your business. It's Garrett Fleck, one of our entrepreneurs in residence. And March 9th, there's our Movers and Shakers networking event, which you're not going to want to tune in. So everybody, I am taping this session. I will also be sending out a short survey for you to complete. I appreciate your feedback, and I hope to see you next time. Thank you.
Thanks very much, everybody. Bye-bye.
Thank you.